your day?
My day was good. And then we got this, we found out that Brenay is
Filing
filing not only an appeal that she's already filed with a limited attorney that we talked about yesterday, but in addition to filing a limited appeal, she has also filed a motion for a new trial. So I've created a podcast so you guys can hear what it is that's happening. We're going to go over the past in a brief overview way. And then we're going to go over the two legal things that she placed in. The first being the appeal.
Yeah.
And then the second being the actual request for a new trial. So we're gonna get detailed here. And again, if you have questions while I'm doing this, then you can answer the questions, or ask the questions rather. So first, let's go into the deep dive, okay? And Sharice, I want you to let me know if you can hear this, because I'm gonna be hearing this on my computer.
Got it.
Okay.
I got you.
Let's go to deep dive first. And again, if you have questions, let me know, because I can get your questions answered. I can get your questions answered, because I'm going to probably have some questions too. So let's begin.
Let's get it started.
Let me know if you can hear it first.
Okay.
Welcome to the deep dive. You hand us the source material, the court files, the motions, the arguments, and we give you the shortcut to understanding what really matters.
Can you hear it?
Yes.
Okay, you can hear it. That's what I'm saying. Make sure you let me know you can hear it. Girl.
I'm sitting here listening to it. I can hear it.
Okay, you can hear it. So again, if you have questions, let me know your questions. If I see them, then I'm going to be able to put them in, and I'll show you an example of what I mean by that in a second. Okay, so what I did was I compiled all the documents. I compiled the motions, stuff that went back in the day. I lumped it all together, compiled it all, so that we can find out what's going on in a clear to understanding way. And you'll be able to ask questions. Miho, baby, we talking about Brenay. She filed only an appeal yesterday, which we knew about. She then went ahead and got herself together and decided she wanted a whole new trial. Yeah. Because as we all know, this is Brenay's world. So she feel like she could do whatever she want to do when she want to do it. Okay. Mm-hmm. So what we're listening to right now is a podcast that I created with all of the documents. Why didn't this attorney get her before? That's a good question. Why this attorney didn't represent her before the case concluded? I can answer that before. I think she thought it was a joke. And she was playing games. She actually had two, it looked like it was two attorneys that she had. And from my understanding, again, first let me say this, we are not lawyers. We're not legal advocates. This happened to be a nerd, and I know how to compile information together in a way that we can understand. But to your point, if you wanted to have this attorney, why didn't you have him before? In my opinion, she didn't think that she needed it. But now
I got different thoughts on that.
Let's get the overview of it.
We are exploring a truly astonishing case out of North Carolina.
Yeah, this is a high-stakes civil lawsuit involving these centuries-old marriage torts. It resulted in a 7-figure judgment that the defense is now fighting tooth and nail to have completely set aside.
That's right. We are dissecting the legal history of Akira Montague versus Brenay Kennard in Durham County Superior Court. And we really need to do this deep dive because this case is just a perfect storm. You've got these archaic legal claims meeting modern procedural chaos.
And a mountain of digital evidence.
Exactly.
And for anyone who might not be familiar with North Carolina law, these hardball torts, as they're called, they're basically legal relics. They're claims designed. Hey there.
Hey, I have
share your thoughts on this?
I have a question. How is this the third or fourth time an award has been given in North Carolina? Wait a minute. That was me.
Coming in, joining us, babies. Please alive.
Still active.
Absolutely. When we call them
please
legal
like
relics,
and share alive.
most states got rid of.
Wait a minute.
Appreciate you.
Like I said, alive. What we're doing right now, we're going over the past first. So we're getting back into the past to talk about how this case happened for dates all the way up to current. Then we're going to go into the actual motions, the appeal, and her motion for a new trial. If you have questions,
Brenay file.
Journey, you're not late, baby. We just started. We're getting started. Because what I did was I grabbed all of the documents. I went to the court place and got all the documents, child, and compiled them in a way in a podcast that we can understand. But we can ask questions too within this podcast because I grabbed all of the documents with the exception of some of the receipts. I felt like that was too long.
Yeah.
Welcome to the deep dive. You hand us the source material, the court files, the motions, the arguments, and we give you the shortcut to understanding what really matters.
And today we are exploring a truly astonishing case out of North Carolina.
Yeah, this is a high-stakes civil lawsuit involving these centuries-old marriage torts. It resulted in a 7-figure judgment that the defense is now fighting tooth and nail to have completely set aside.
That's right. We are dissecting the legal history of Akira Montague versus Brenay Kennard in Durham County Superior Court. Yep. And we really need to do this deep dive because this case is just a perfect storm. You've got these archaic legal claims meeting modern procedural chaos.
And a mountain of digital evidence.
Exactly.
And for anyone who might not be familiar with North Carolina law, these heart balm torts, as they're called, they're basically legal relics. They're claims designed for the, I guess, emotional and financial destruction of their marriage by a third party.
And specifically, the plaintiff, Akira Montague, she brought 2 claims. The first one is called criminal conversation, which essentially just means proving sexual intercourse happened with a married person and their spouse didn't consent.
Nice. They're not using friendly words.
The second one, though, and this is often the more damaging claim, is alienation of affection. And for that, you have to prove that the defendant maliciously and intentionally caused the end of a genuine marital relationship.
Oh, hey there. How could we help?
Can you explain that criminal part?
That is a great question.
Okay, let's unpack this.
When you hear criminal conversation, you naturally think of a crime.
Right, something the police get involved in.
But in the context of this civil lawsuit, it is not a criminal offense.
The name is just a centuries-old holdover.
Exactly. It's an archaic legal term.
In this case, the jury instructions confirm the legal definition is really simple.
Criminal conversation is just sexual intercourse with the spouse of another person during their marriage.
That's the definition, according to the judge's instructions to the jury.
And you just have to prove that a single act occurred before the couple physically separated permanently.
The law specifically tells the jury not to consider whether the spouse consented or if there was love and affection in the marriage.
It's a very narrow technical tort focused only on the act of sex itself.
And as we will discuss later,
Brenay.
The damages for that claim, the criminal conversation part, are treated differently.
They can be discharged in bankruptcy, unlike the other claim.
So the criminal part is just a name that's stuck around, but it is purely civil litigation today.
Okay.
Absolutely. Thanks for chiming in.
Now back to that second claim, alienation of affection.
And we were just about to explain that for that, you have to prove that the defendant maliciously and intentionally.
Timex, I saw. We're going to talk about that too. What we listen to, if you're just coming in, I did a podcast that is interactive where we can ask questions. And we're going, hey, Susie Q, baby.
She is so genius. She's so smart.
Thank you. I compiled all of the court documents with the exception of the receipts and then put this podcast together that we can ask and hear what's going on. And then we're going to go over her 2 other things. So if you had questions.
Y'all getting some deep dive exclusive stuff here. Please share this live.
Cause the end of a genuine marital relationship.
And the money involved here tells you everything about how contentious this was from day one.
Even for the criminal conversation claim, which we just clarified, the plaintiff was seeking significant damages.
In her amended complaint, the plaintiff was seeking damages over $150,000 just for that claim.
Yeah.
But the demand for alienation of affection, that alone was over $1 million.
Plus another $4 million in punitive damages.
These were impressive claims.
It was an all-out legal assault.
So our mission today is to follow the precise steps and the missteps that led this case from a standard filing to a $1.75 million jury award.
And then we're going to analyze the defense's really sophisticated legal moves they're making right now to argue that all these procedural failures just corrupted the entire trial process.
Exactly.
Okay, let's unpack this journey because the path to trial was just riddled with breakdowns.
It really was.
The initial complaint was filed in May 2024.
The defendant's attorney, Andre Truth McDavid, he appeared in June.
And the trial was initially set for May 19, 2025. Nearly a full year later.
Okay.
Right. Everyone had plenty of time to prepare.
Plenty of time.
Plenty.
And yet, preparation on the defense side was
none.
It was basically non-existent.
The sources show the plaintiff started discovery right away.
Standard practice.
Standard practice. The first set of interrogatories and requests for production went out in June 2024.
Followed by a second set in July.
This is the routine information gathering phase. Key documents, testimony, facts.
But the defense just stalled. They secured 2 separate motions for extension of time, pushing that deadline all the way to September 23, 2024.
Why does that matter so much here?
It matters because the
exactly.
documentation confirms that even after those 2 extensions, the defendant fails to produce anything.
Wow.
No documents, no responses to the interrogatories, just silence.
Now, I'm pausing right here because this is important, because in these upcoming, in her motions, which we're going to go over too, she's trying to act like it was because her attorney did not inform her. Before the attorney even dropped out, Brenay didn't provide any documentation to the plaintiff or even her own attorneys. So they can't pull up information
Out the sky.
They were not in your bedroom, baby.
Okay.
Couldn't Akira's attorney argue that this was Brenay's objective all along to jeopardize the trial? That's what Sharice said earlier. I'm sure Robin gonna have a lot of it for that. Yes, she can. If you're not helping your attorneys, you're definitely not giving that information to the plaintiff's attorney, then how is that our fault? But let's continue.
Correct.
So this forced the plaintiff into a whole other legal fight just to get basic information.
They had to file motions to compel and for sanctions, not once, but 3 times.
3 times.
September 2024, November 2024, and then again in April 2025.
That kind of stonewalling, it adds so much cost and delay, but it also tells a story about the defense's strategy.
Or
lack thereof.
It does.
It suggests they either had nothing to offer or they were actively trying to hide something, which I assume that fed into the court's later decisions.
Absolutely. You can see the frustration in the court record.
Yes.
But then the procedural chaos, it just intensified dramatically.
Please like the live, baby.
When the defense attorney
He's like the live. Hey, you got a heart.
Oh, thank you, baby. I appreciate you. Please get live. If y'all feel like this information is helping y'all, again, if you have questions regarding these documents,
yes,
whatever they are, I can ask specific questions within the documents based off of what I did. What I did was I compiled all of the legal documents, made a podcast for us to understand that is, baby, you got a heart.
Thank you. Thank you, Latwala. I appreciate that.
And we're going to be able to ask specific questions within these documents. So we ain't just talking. Oh, I got a flash code. Let me put it up.
Me too. Help us get our flash code, guys.
Get our flash codes, babies. So that's what we're going on here.
The attorney tried to withdraw twice.
January 30, 2025, and then again on April 1, 2025.
But here's the detail it comes out. He failed to calendar hearings for either motion.
Which is not a typical oversight. Not in high court.
Yeah. I have a question. Is that what reason does it list that the attorney tried to withdraw from the trial?
That is a critical question.
Okay, let's unpack this for a second.
Thanks,
Because the
Kennard.
attorney, Mr. McDavid, did give reasons.
His motion to withdraw in January 2025 specifically listed a few points.
One key reason was simply that the defendant, his client, could not pay the outstanding balance with the law firm.
Right. He stated the firm couldn't ethically assist in creating a large financial burden.
Which is a valid reason for a lawyer to step away.
He also noted that the opposing side was, in his opinion, intentionally filing unnecessary and/or lengthy motions.
He claimed they were trying to increase the cost of litigation.
What's really fascinating here, though, is how the court viewed those reasons versus the timing.
The judge denied those first 2 written motions.
Yes, the court acknowledged the defendant consented to the withdrawal.
But the judge found that the timing would have a materially adverse effect on the defendant.
So even if the lawyer...
Y'all hear that, though, right? Thank you, Miho, baby. I appreciate you. I hope I'm saying your name right, because I didn't put 2 or 3 holes. Y'all hear that? But I'm going to ask a specific question in a second.
Okay.
Valid reason. Hey, yeah, what's up?
Could one of the reasons for the withdrawal be that the attorney was not getting Brenay's information? She was not providing evidence to her own attorneys.
That is a phenomenal insight.
And you are hitting on a major theme here.
While the motions filed by Mr. McDavid didn't explicitly cite the client's non-cooperation as the reason for withdrawal.
The court records absolutely show a profound failure by the defendant to provide information.
That non-production of evidence directly leads to the lawyer's failure to conduct discovery.
The plaintiff's motions to compel filed repeatedly detailed exactly what was missing from the defense.
They were missing lease agreements, co-signing information, bank statements, and critically, documentation of the defendant's income as a social media influencer.
They needed copies of emails and text messages between her and the plaintiff's ex-husband.
So it really wasn't money. No, it doesn't look like it at all. No, she wasn't, and she wasn't listening about stop talking about this case.
Nope.
No, okay.
All the way back to January 2023.
So even though the attorney cited non-payment as the reason to withdraw, His subsequent lack of discovery is tied to the client's failure to hand over this key requested evidence.
And that lack of preparation,
That's so
intentional or
beautiful.
not,
Thank you.
is precisely what the defense is now using to argue the whole trial was prejudiced.
So if we connect this to the bigger picture, the attorney's failure to perform discovery, which was based on the defendant's noncompliance,
It directly led to the judge's initial denial of the withdrawal.
the judge denied the withdrawal, as we mentioned, because the client needed adequate counsel.
This is a classic conflict between an attorney's right to withdraw and the client's right to adequate counsel.
And that tension is exactly what sets up the defense's final major argument for a new trial later on.
Because, oh yeah, let's hear it.
Before we go there, so basically the judge tried to prevent what Brenay is trying to do now, in that he didn't want her to lose her attorneys because he knew she was not going to be able to represent herself in such a large civil suit.
That is a brilliant way to frame the judge's original decision.
You've nailed the judicial tension here.
The judge absolutely recognized the risk.
When he denied the first two written motions on April 3, 2025, he specifically found that allowing withdrawal would have a materially adverse effect on the defendant.
That is a key legal phrase.
It means the court knew she would be prejudiced.
She, being a social media influencer, lacked the legal sophistication to go pro se, especially with no discovery done.
The judge foresaw the exact disaster that later happened at trial.
Which is why the defense is now using that initial denial as ironclad proof of their prejudice.
That procedural error is argument C in the Rule 59 motion for a new trial.
That's right. The judge tried to prevent the unfairness.
But then, in a final twist, he later allowed the withdrawal anyway.
Exactly.
He got out of the case.
Yes, on May 13th.
But
6 days before.
But isn't it true that Brenay signed or requested that her lawyers get off the case?
Oh, that is absolutely true.
You are paying attention to the details.
Brenay Kennard did consent to her attorney's withdrawal.
We have copies of the motion to withdraw.
She signed the consent line on at least 2 occasions.
One in October 2024 and another on the January 2025 motion.
So she actively agreed to let the attorney, Mr. McDavid, leave.
But here's where it gets really interesting.
Her current lawyers are arguing that her consent doesn't matter.
They argue that because she is a social media influencer, not a lawyer,
she lacked the legal sophistication to understand the severe consequences.
Consequences going into a massive civil trial without a single piece of discovery done.
So while she consented, the court's job is to protect the integrity of the process.
The current defense argument is that the court should have protected her from her own lack of legal knowledge.
It's a huge procedure.
Yep, go on.
But short of forcing her to pay for an attorney, what could they have done? They can't force her to pay for an attorney. They gave her time and extended it, and she did not take advantage, correct?
That is the central, painful dilemma for the court.
You're absolutely right. They cannot force her to pay for counsel.
And the court can't force an attorney to work for free, especially in civil litigation.
What the court can do, and what the court initially tried to do, is prevent manifest injustice.
No,
The
Susie,
judge's
no
initial denial of the
him.
withdrawal was a direct attempt to force the attorney to prepare the case.
Even if the attorney planned to withdraw later, they should have completed the discovery phase.
That would have at least given her the essential accoutrements for trial, as her defense later put it.
But once the
But they can't give her set that up for her if she's not providing the evidence, because it's apparent that she didn't provide the evidence because the plaintiff's attorney never got it.
That is a phenomenal point.
And it absolutely cuts to the core of this whole mess.
You're asking, how can the attorney prepare discovery if the client is stonewalling them?
Yes.
It's the lawyer's worst nightmare.
The court filings confirm your suspicion.
The plaintiff's motions detail the missing items: bank statements, social media income documents, all the communications.
All of which the defendant had access to but failed to produce in September 2024.
So, yes, the defense attorney, Mr. McDavid, had virtually nothing to pass along to his client.
He was trying to conduct discovery based on missing or incomplete client responses.
Which leads right back to the prejudice argument.
The defense is claiming the court failed the defendant by allowing the attorney to withdraw while having amassed none of those vital trial case accoutrements.
The issue is less about whether the attorney could force the client to provide evidence,
and more about the court's decision to allow the attorney to leave when the case was empty.
It put the non-lawyer client in an impossible situation.
The judge's eventual decision to allow the oral withdrawal, despite the earlier denial, is the key flaw the defense is targeting now.
Yes, on May 13, 2025, just 6 days before the original trial date.
An oral motion was granted.
The trial was eventually pushed to November.
You are also direct that she was given time.
Multiple discovery deadlines were extended, but the defendant did not.
And that lack of preparation, as you pointed out, had real consequences.
Even after she was representing herself, the court issued sanctions.
Right, because of that ongoing failure to comply.
And that procedural breakdown had real, tangible consequences for her.
Please like the live, babies. Like the live. We are going over. What I did was I compiled. So this is not an app. I had to go in and put information in. It's almost like my own thing. I had to go in and grab a lot of documents, put it together, prompt it to ask the right questions, and based off of that, I'm getting what I'm getting. So I had to.
This is exclusive.
Ask questions, prompt it the way I needed to prompt it, and then this is what I got. But she had two attorneys. That chick did everything but pay for a lawyer. Exactly. The lives, baby. Please like the live.
Please like the live. Please share it, repost it. Please follow us.
We are giving y'all we are going over the case in detail. And if you have specific questions about even documentations within the documents that were filed, please ask them. If we see them, we'll pin them. And then after we do this, we're going to go over the exact motions that were done. And we'll be able to ask questions for that too. I love how y'all breaking it down. Thank you, Yanni. I appreciate you. Only thing she thought about was Tim and Eaton.
That's it. That's all.
In May 2025, the court sanctioned the defendant $2,000.
That was to cover the attorney fees the plaintiff spent just chasing compliance with discovery.
The plaintiff later alleged that the defendant still didn't pay the full amount.
That's despite filings suggesting she was earning around $11,000 a month from her social media work.
So the case was already marked by non-compliance and costs before a jury was even seated.
What a staggering setup for a civil trial.
Okay, let's pivot to the trial itself in November 2025.
The defendant proceeds pro se, representing herself.
And the jury comes back with a verdict that just completely upends her financial life.
It did. On November 10, 2025, the jury found her liable on both claims.
They awarded $250,000 for criminal conversation.
And then a massive $1.5 million for alienation of affection.
So the total judgment entered stands at $1.75 million.
$1.75 million.
Okay, before we get into the new trial motion, let's pause on the evidence.
What led to this huge sum?
These are extremely personal torts.
And the defense tried to suppress the key material.
They did. They claimed they were obtained illegally.
They sought dismissal under the...
I got a flash goal, baby. So if y'all can help me reach, that would be great. So if you find this helpful, I got a flash goal.
It's the flash goal.
Help us reach the flash goal if you find this helpful.
Doctrine of unclean hands.
For listeners who aren't familiar, what exactly is unclean hands?
It basically means a party can't ask the court for help if they themselves did something wrong.
Something wrong related to the case.
In this case, the allegation was that the plaintiff violated North Carolina law.
Thank you.
This was to get private materials.
Like videos and messages from the defendant's or her current husband's devices.
So the argument was, the evidence of my wrongdoing was obtained through the plaintiff's wrongdoing.
Therefore, you have to throw it all out.
That's the argument in a nutshell.
But clearly, the evidence was admitted and used.
Yes.
The trial exhibit logs, they detail this intense reliance on digital data.
We're talking multiple video recordings, hundreds of text messages, photos, even
Cash App receipts showing money transfers.
Detailing the transfer of funds, a daycare invoice.
And even specific notes that were just labeled Britney Cherry notes.
This verdict wasn't based on simple testimony. It was a digital forensics case.
That really underscores how modern tech has just turned private arguments into public, admissible evidence.
Okay, so now she's faced with a $1.75 million judgment.
The defendant, with new lawyers, immediately files a powerful challenge under Rule 59.
What is Rule 59, and what are the three prongs of their challenge?
So Rule 59 is the standard legal tool you use after a trial.
It asks the judge to either set aside the jury's verdict and grant a new trial, or to amend the judgment.
You're basically saying the jury got this wrong or the process was flawed.
Wow.
Exactly. And the three core arguments here are: one, the damages were excessive;
two, the evidence was insufficient to support those damages;
and three, the whole verdict was prejudiced by all those procedural failures.
Let's start with that first one, excessive damages.
This is where the defense attacks the actual jury form, citing...
Okay, guys, so this is where we're going to start getting into detail about the 1.75 judgment, because what they're saying now is a possibility that it was excessive, and they're going into this detail. Going into a little bit more detail. I will say, if she had any Hail Mary, it would probably be in reducing that.
Yes.
But chances of getting it thrown out and all of that are mute. If you just popping in, what we're doing is I compiled all of the documentation, the court documents, put it into a podcast type form so that we can not only listen to it, but I can also ask questions as we go along. So if you like the live and you find this useful or helpful, please, if you enjoy
Share, like the live, follow. We appreciate it.
And it hinges on a really technical but critical distinction the jury failed to make.
Yes, this all comes down to nominal versus actual damages.
Okay.
So when a jury finds liability for something like criminal conversation, they have to award some amount of damages.
If the plaintiff failed to prove any specific financial or emotional injury, the jury is supposed to award nominal damages.
And what's that, like $1?
It's a trivial amount. Historically, yes, $1.
It's just a symbolic acknowledgement that a technical wrong occurred.
And actual damages.
Actual damages are the real money, compensation for verifiable losses.
Things like mental anguish, economic harm, loss of support from the marriage, what's called loss of consortium.
And crucially, the jury instruction said the jury must award actual damages only if proven by the evidence.
Otherwise, they default to nominal.
And on the verdict form, the jury just wrote $250K for criminal conversation and 1.5 M for alienation of affection. No distinction.
Precisely. And the defense argues it's impossible to know what the jury intended.
If the jury...
Okay, so that's what we got a problem at. They didn't specify how the money, what is for the punitive damages, what is for the alienation of affection. They didn't specify. Let me
thought $250,000 was nominal damage.
Oh, yeah. Let's hear it.
Can you clarify again how the jury messed up in terms of deciding how the money should be distributed, or what the money is for, rather?
That is a perfect question for us to quickly circle back on.
Okay, let's unpack this specific point one more time because it is the most technical part of the post-trial motion.
Absolutely. The judge gave the jury very specific instructions.
For both claims, criminal conversation and alienation of affection, the jury had to consider two types of damages.
Nominal damages, which is the symbolic $1 for technical harm.
And actual damages, which is the money for mental anguish or economic loss, if proven by the evidence.
The judge told them if they found actual damages, they write that amount.
If they fail to find actual damages, they must write a nominal sum like $1.
Here's the critical mess. The verdict form only had one blank line for the final amount.
They wrote a single large value on each line, $250,000 and $1.5 million.
They failed to specify this portion is nominal and this portion is actual.
So we can't tell if the jury mistakenly thought $250,000 was the nominal amount.
Which, if true, would be grossly excessive and influenced by passion.
Or if they meant it as actual damages, which the defense argues there was no evidence to support.
This ambiguity, the failure to follow the mandate to specify the type of damage, is the legal flaw.
It's why the defense is challenging the entire award is excessive.
It creates uncertainty and opens the door for a new trial.
So if the jury thought $250,000 was nominal damages, that's grossly excessive.
It suggests the jury was just influenced by passion or prejudice.
And if they meant it as actual damages?
Then the defense pivots to their next argument.
That there wasn't enough evidence.
Okay, guys. So, like we already said, the chances of it being reduced are probably a little bit higher than doing a whole new trial. Because Brenay had plenty of opportunities, as we've heard within this podcast, she had plenty of opportunities to get an attorney. The last date was in May. She requested an extension. She did not get an attorney. Instead, we all saw her running around on doing TJ Maxx and all of these kind of things, buying stuff. Vegas. She had the Vegas trip. She had all of that. So she looked like she could take care of herself and get herself an attorney. She didn't choose to do that. So that is where the people messed up. When they gave her the verdict, they didn't specify what was for
what. Yeah.
And so having it reduced is a possible chance of that. Having another court trial, I doubt that very seriously.
No. They don't keep playing with you.
That number.
The ambiguity itself is the fatal flaw.
And they cite a fascinating bankruptcy case in Re Martha Medlock Gallagher.
Why is a bankruptcy case relevant to a civil tort verdict like this?
It's all about the long-term legal ramifications.
In bankruptcy law, debts from criminal conversation are treated differently than debts from alienation of affection.
Criminal conversation debt can be discharged.
Ah, I see.
So the jury's inability to specify which dollar amount is for which type of damage creates this future uncertainty.
About the very nature of the debt itself.
The defense is arguing that if the verdict is so vague, it could cause legal confusion down the line.
It proves the jury instructions or the form were just structurally unsound.
That is a really sophisticated argument.
Okay, let's move to argument B. Insufficiency of evidence for actual damages.
This directly challenges that massive $1.75 million figure.
Right. Here, the defense argues that the plaintiff presented, and I'm quoting, little to no evidence of actual damages to support such a huge award.
To get to 1.75 million, you need to show detailed proof of the plaintiff's loss.
But the motion points out specific gaps.
Huge gaps. They say there was no testimony or documents about the cost of the plaintiff's therapy or counseling.
This was because of the affair.
And more importantly, insufficient evidence of the ex-husband's salary or what he contributed financially to the marriage.
Now, like Sharice said, she didn't ask for it. But again, that goes back to you not having an attorney. That's not the court's fault. So had you had an attorney, they would have been able to ask those questions. You can't now come back and ask for a new trial when you had an opportunity to get one.
Do your homework.
And she couldn't even say that it was because of money. In the recent motion for a new trial, she said she was emotionally charged or something like that. We're going to get more information on that in a second.
She was emotionally charged.
She was emotionally charged or emotional or what have you. That's not enough. You can't get another court date because your emotions was in the play. As a matter of fact,
you caused all this.
Made jokes in a video that said, I make her uncomfortable. Make her uncomfortable. So you seem like you could fine. Thank you, me, ho, baby. You seem like you were just fine. So now you're emotional? No.
That's critical.
Please like the live, people. Thank you so much. We appreciate you.
The consortium is often tied to the financial support, the care, the partnership you lost.
If you can't show what the financial loss was, it's very hard to justify a $1.75 million figure. And the defense even counter-argued that evidence presented at trial actually suggested the plaintiff's ex-husband couldn't financially support her.
That her mother and other relatives had to step in.
Which completely undermines the claim that the defendant alienated some financially robust spouse.
It certainly challenges it.
That detail really cuts to the core of the economic damages claim.
Okay, finally, let's briefly revisit argument C.
The procedural breakdown we discussed earlier with the attorney withdrawal.
It's the argument that the attorney's abrupt withdrawal after the court acknowledged the prejudice
and the lack of discovery, which was hindered by the client's non-compliance.
Created an unavoidable prejudice.
The motion argues the defendant, a non-lawyer social media influencer, simply lacked the legal sophistication needed to go pro se.
We talked about how the judge tried to prevent this from happening initially.
This inherent prejudice, they claim, proves the verdict must have been influenced by things other than the evidence.
Which would require a new trial under Rule 59.
That's the argument.
So what does this all mean for the future of this case?
We have this massive 7-figure judgment resting on two of the most controversial centuries-old torts left in the U.S. legal system.
And this verdict is now being challenged not so much on the facts of the affair itself,
but on these very technical, procedural, and evidentiary flaws, like the jury's damage specification. This case is just a critical study in how legal procedure becomes decisive when the stakes are highest.
The failure to conduct discovery effectively sealed the defense's fate before the trial even started.
Which perfectly set up this Rule 59 challenge.
It did. And it also highlights the need for meticulous judicial execution.
That these technical mandates, like requiring a jury to specify if damages are nominal or actual,
wrote it down.
becomes the absolute centerpiece of legal validity.
When verdicts hit the
specify how the money supposed to went down.
And as we close this deep dive, the one element that really stands out is the weaponization of our personal digital lives.
This whole case was built and proven by admitting private videos, hundreds of texts, even cash app receipts.
It's all out there.
For anyone involved in conflict, this case shows that modern technology had just dissolved the boundaries of private life.
What stands out to you about the sheer vulnerability of your digital history when high conflict civil litigation comes calling?
That is certainly something to consider as this saga continues.
Thank you for joining us for this deep dive.
Thank you. So
appreciate that. That was, first off, that was genius.
Thank you.
To be able to put all that stuff together. I know what it took for you to do that, to put all that together, to break it down. Genius.
What I did was I compiled I had to download all the documents, and then I had to enter into a state of prompting, where I prompted to ask certain questions within the legal documents. So that was the overview. We're going to go even, thank you, Dominican, I appreciate you. We're going to go even further.
Thank you, Lisa, for being in the fan club.
Thank you, June Jim. Said that was smart. I appreciate that. Yes, that makes a lot of sense. Thank you, Yanni. The lives, baby. We're going to go into the part 2 of this. So we're taking a pause right quick. What do you think so far, what you heard? Thank you for the heart.
Appreciate y'all. Thank you. Running them up.
I appreciate it so much. Before we go into that second one, Sharice, what do you think so far?
So I think that this is all smoke and mirrors.
Thank you,
I had a brief moment of, did she set this up from the beginning? Because I know she's got first off, the lawyer that's helping her now, the partial lawyer or the
Thank you, Maria.
whatever,
Thank you, Miho.
the lawyer that's helping now, to me, was actually in there during the trial. She was actually standing in there. We saw her on day 2 or 3 or whatever with Brenay and them. So
we believe that's her.
We believe that's her. So you've had access to all this. Where was she in the beginning? My thing is, she's been sitting there, she's been listening, so that she could
that's her,
do exactly. If that's her, if that's her,
be room.
If that's her, she had access to all of this while she was in trial with Brenay. In my opinion, to do this right now, it's more stall tactics. It's more. Thank you so much. It's more tactics to not pay, to delay, because once, I believe you looked up, once the appeal had been filed, the interest stops.
She's still gonna lose. Yes, baby, mind your business.
So I just think it's more smoke and mirrors, and it's actually a waste of time. Hearing the breakdown like that you just did lets you know how much time for a whole year and how long this thing had drug out, and she played and didn't provide anything and thought it was a game, in my opinion. So this isn't going to work either.
And so, unlike you, I don't think she's smart enough to think in advance. I do not. There's nothing about her that's calculating to me. The only thing that's calculating is when it comes to Tim. For that, she's very calculating. She knew what to do, how to do it, what to say to get herself into, number one, into Akira's good graces, then into eventually her friendship, then into literally her house, then into or with her husband. That's part she's calculating. All of the other stuff, I think she really did. And a lot of people say it over and over again. I think that she's cocky.
Yeah.
I think that she thought that she was going to get away. She had like we already talked about. First of all, shout out to Miss Diva. Miss Diva, you still here?
Miss Diva, man. Miss Diva,
Miss Diva. So much, man. You let me know what's going on in these TikTok streets. You don't let me miss nothing.
Sure do.
Now that it's on The View, now that they're talking about it in the TMZ, the news, and all of this kind of stuff, now that it's getting more popularity, she wants to get another trial. Outside of that, her wanting Tim, she had no idea it was going to be this big. And you had chances after chances after chances, because even with your attorneys, as we just listened to, we're going to listen to we're going to go deep into the 2 motions that she filed, the appeal. Right. And we're going to go deep into the 59 now. And if you have questions about the documents, let me know, because I can ask them.
So Marcy already said how long will the appeal take. That's going to be addressed when we listen to the second part.
Yes, because it's also going to be paid. So North Carolina has been moving slow. Like, even to responding to the lawyer's original thing to let me out, it seemed like it took some time. So now, whether or not they're going to put the speed on this one, since all eyes is on it.
Yeah, this thing blew up. And I don't think they knew, they anticipated it was going to blow up like that.
All right, baby, we're going to listen to part 2. If you could start liking it again so that you can get us over 30,000. That's helpful. Let's go into part 2.
I think you're right. Your favorite
is about deep diving into the 2 motions, the appeal and the 59, which is where she's requesting a new trial. Listen.
Welcome to the deep dive. Today we are plunging into a really high stakes legal battle straight out of North Carolina. It's one of the handful of states left where you can still be taken to court for interfering with a marriage. They call it a heart bomb tort. And
the stakes here, they could not be higher. We're looking at the immediate, almost explosive aftermath of a truly stunning jury verdict.
Yeah.
It's the case of Akira Montague versus Brenay Kennard. And the jury awarded the plaintiff a colossal $1.75 million.
Wow.
So what we're dissecting today is the highly procedural, almost desperate attempt by the defendant to have that entire judgment just thrown out. The argument is that the trial process itself was fundamentally flawed.
That's right. Our mission here is to really get into the weeds of the post-trial motions, specifically this Rule 59 motion for a new trial. This deep dive it's a masterclass in how a massive civil victory can completely unravel.
Right. It can fall apart based on alleged legal or evidentiary or even procedural catastrophes that happened months, maybe years before the verdict was even read.
So let's set the scene. The plaintiff, Akira Montague, she successfully sued the defendant, Brenay Kennard, on the 2 main heart bomb claims that North Carolina allows.
Exactly. The first one is criminal conversation, or CC, which is the act of sexual intercourse with a married spouse.
Is the retrial and appeal the same thing? No, so the appeal is the appeal. So they're doing two things. Number one, they're appealing what the judgment was, and then they're asking for a whole new motion, a whole new trial too.
I think one cancels the other. Either you're appealing one thing or you asking for a new trial.
Okay.
And the second is alienation of affection, or AA. And that one demands proof of malicious interference with and this is a key phrase, a genuine marital relationship that causes its destruction.
And the jury, they delivered their judgment on November 10, 2025. And it was huge. $250,000 for a criminal conversation.
And then a stunning 1.5.
Oh, hey, I think our listeners got something to say.
Yeah, I do have something to say. So can you explain the difference between the two motions she filed for an appeal and the 59, I think you're saying? Can you just give us information on what she filed after the verdict?
That is a fantastic question.
Absolutely. We were just about to dive deeper into that.
Okay, let's unpack this.
In other words, shut up,
The
lady.
defense team, Brenay Kennard's new,
Let me cook.
they actually filed for two related things.
One is the motion for a new trial, which we were just discussing. That's the Rule 59 motion.
And the other is the notice of appeal.
They did both because they want 2 layers of protection against the judgment.
Think of the Rule 59 motion as the immediate Hail Mary pass right back to the original trial judge.
It's an internal
Leave
challenge.
laughing at
They
me.
are asking the same Superior Court judge who presided over the trial to look back at what happened and say, wait, that process was so flawed, I need to throw out my own verdict and start over.
It deals with things like procedural errors, which we'll discuss, or excessive damages. It's a faster route to
Thank you,
potentially getting the
Kesha.
whole verdict set aside right now.
Now, the notice of appeal is the second part. It's like formally reserving your seat on the train to the higher court, the Court of Appeal.
That notice is essentially saying, if the trial judge denies our Rule 59 request, we are officially ready to take this entire case to the next judicial level.
And this new counsel, they filed a limited appearance specifically to handle those 2 tasks. The post-trial motions like Rule 59 and the formal notice of appeal.
Yep, go on.
So I just want to make sure. So you think that this is set up for once they're denied, or if they're denied, to go to the Supreme Court or the next level?
Next level up.
That is precisely the strategy here.
Yes, you got it exactly right.
The notice of appeal is the procedural safeguard.
They're setting up the next move now.
If the Superior Court judge denies the Rule 59 motion for the new trial request, then the appellate process immediately kicks off.
It's basically saying, we don't agree and we are prepared to argue this to a higher court.
And that higher court in North Carolina would typically be the Court of Appeals.
That new counsel, they filed a limited appearance just for these 2 post-judgment fights.
So they're legally authorized to challenge the verdict
Can you pause it real quick?
level, and then formally start.
What you say?
We had a question. What is the limited appearance? What does that mean?
Okay, I'm gonna let them finish this one out, and I'm gonna grab that one next.
Okay.
Just so you know, we briefly went over it yesterday, but I'm
Yeah.
interested in seeing if she changed. So what a limited appearance basically means is I'm doing clerical, I'm doing your motions, I'm setting up the paperwork, I'm doing all that kind of stuff that you don't know how to do. But I'm not your actually attorney. I'm not your attorney.
Full attorney,
But
right.
this new request for this new trial is making me feel like it may be. So I'm gonna ask that question next.
Okay.
And the
Thank
Supreme Court, they have different courts, high courts in certain. So I ain't talking about the big boys.
Supreme. Yeah, no. It could be a
Yeah,
superior.
different
It's next level up.
Yeah.
Mhm.
Let me see what she says, and I'm gonna ask that question. The next question is what's the difference between what is the limited appearance? More information on that.
The process of appealing the entire judgment if they lose that first motion.
It's a strategic move that covers all immediate bases after a massive verdict, like $1.75 million.
It makes sure they don't miss any deadlines to challenge that judgment, regardless of whether the trial judge agrees to toss it or not.
It's really smart. Oh, go for it.
I have a question. So the limited appearance, she did a limited appearance in the appeal, but the other motion, is she now going to be her attorney for that? Are you able to see with the documents?
That is a phenomenal question about the scope of representation.
Okay, let's unpack this question about the limited appearance.
Based on the documents, the new attorney's appearance is in fact explicitly limited.
It's defined to cover exactly 2 things.
First, the filing and appearance on post-trial motions in Superior Court. That's the Rule 59 motion we are discussing.
And second, the filing of the notice of appeal.
So yes, this new attorney is her counsel for the Rule 59 motion for a new trial.
But only for that. The limited appearance means they are not taking over the entire case or providing full representation.
It's a very specific contract, almost a surgical engagement.
It's all about fighting this current verdict and setting up the appeal if they lose that fight.
Once those 2 specific tasks are finished, the Rule 59 motion is heard and the appeal
Thank you,
notice is
Storm.
filed. This attorney's job under the limited appearance is technically done.
It's a key strategy to manage costs and focus the legal fight.
Ah.
Well,
Yeah,
I hope that doesn't mean that she's going to represent herself again.
Fight.
That is a completely fair concern given what happened before.
Okay, let's unpack this. You are highlighting the biggest risk of the limited appearance.
While this new lawyer handles the Rule 59 motion and the appeal notice, they are not signed up for anything else.
That means if the judge grants the motion for a new trial, the entire lawsuit resets.
And at that point, unless Ms. Kennard hires this attorney or another one for general representation, she would technically be back to representing herself. Interesting. The defense team seems acutely aware of this danger.
Because if the court grants the new trial, the motion specifically requests that the parties be ordered back to mediation.
That request is a strong signal that the defense wants to avoid another trial, especially if their client would be pro se again.
That new lawyer is ensuring the legal challenges are covered. But the next step, the actual retrial, is still uncertain for Ms. Kennard.
So we're keeping our fingers crossed for her that they can find a path forward with counsel or perhaps mediate.
Yeah, we ain't trying to see
That
that.
allows them to jump in just for these immediate post-verdict challenges.
Which is really smart.
Exactly. Now that $1.75 million award, which this limited counsel is now fighting so hard against.
They're using Rule 59 because it allows the court itself to set aside its own verdict.
It orders a brand new trial if certain fundamental injustices happen.
Things like excessive damages, insufficient evidence, or procedural errors that just denied a party a fair shake.
So this is like asking for major legal surgery, not just a few tweets.
Precisely.
Okay, so let's unpack the core of the defense motion.
It seems to argue that the trial was compromised long before the jury was even seated.
All because of a really dramatic and messy pretrial timeline with her original lawyer?
That's the starting point. The motion argues the defense was fundamentally crippled.
That the defendant, Ms. Kennard, was left utterly exposed due to the inactions of her first attorney, Andre Truth McDavid.
And the documents show a clear attempt by the attorney to get out of the case.
He filed to withdraw back in January 2025, and then again in April.
Yes. And here's where the procedural mess really starts to build.
Those first two motions to withdraw weren't properly set for a hearing. The attorney never calendared them.
So that delay pushed everything to the brink.
It did.
Oh, yeah.
Oh, okay, so the couple things. The fact that the attorney didn't have...
Okay, let's unpack those couple of things.
You are interested
Let me finish.
in the details of... Oh, go for it.
Okay, the attorney was not given the information because Brenay requested him to withdraw. Do you see that in the documentation?
That is a critical point. You are asking who initiated the breakup with the first attorney.
Okay, let's unpack the withdrawal dynamic between Ms. Kennard and her first lawyer, Mr. McDavid.
You're absolutely right to look for that detail.
The documents show it was a mutual decision, or at least one with her consent.
The initial written motions to withdraw, which were filed in January and April 2025, both included a section for the defendant's consent.
One of the motion documents, in fact, states, and I'm quoting here, defendant wishes for counsel to withdraw in her matter and joins in this motion to withdraw.
And she signed it. Her signature, Brenay Kennard, is right there agreeing to the withdrawal in October 2024.
So yes, she consented to those withdrawal motions very early on.
Now, the final withdrawal, which happened in May 2025, was also granted by the court with her consent in open court.
So it wasn't just the attorney trying to ditch her. The defendant was actively agreeing, even requesting that he leave.
And that's exactly...
Hey, yeah, what's up?
And to add to that, one of the reasons was they didn't have enough evidence because it appears that Brenay was not giving evidence necessary to help defend her.
You've connected the two critical failures perfectly.
Okay, let's unpack that double-edged sword.
You are absolutely correct that the evidence issue was two-sided.
Not only did her lawyer do nothing for her, but she was also actively struggling to comply.
The plaintiff's filings show they had to file multiple motions.
Things like motions for sanctions and contempt against Kennard.
This was in late 2024 and
That's
early
why they left,
2025
right.
While she still had her first attorney.
These motions were just to get basic
Can't predict the
information.
outcome.
They needed documentation of the income she received as a social media influencer.
And crucially, missing communications and financial records about the plaintiff's husband.
Even after court orders to produce documents, the plaintiff claimed the responses were incomplete.
So she had problems turned over discovery, and her lawyer failed to conduct discovery on the other side.
That procedural chaos is exactly why the current defense team is fighting this point in the Rule 59 motion.
Because the court is generally reluctant to overturn a decision that the party consented to.
The new defense team argues that even though she consented, a non-lawyer litigant cannot fully grasp the prejudice.
Especially not the prejudice of losing their attorney just before trial.
She was left with zero discovery, both incoming and outgoing, to defend herself.
So even with her consent, they argue it created an inherent prejudice to the defendant.
It was a disastrous move for her case, and that's the argument they're making now.
That failure to conduct discovery is a key part of their attempt to
You can't do discovery if she
now
don't
let's
give
revisit
them.
the details of the withdrawal mess.
So while she consented, the core issue is the timing and the lack of preparation.
The first two motions to withdraw weren't properly set for a hearing, which pushed everything to the brink of the May 19th trial date.
Which is where the procedural mess really starts to build.
The court, remember, initially denied the withdrawal on April 3rd.
That feels like a crucial detail for the current motion.
Absolutely. The judge was trying to protect Ms. Kennard, as we noted earlier.
The court was crystal clear on the reasoning for denying it.
It ruled that letting the attorney leave so late would have a, and I'm quoting here, materially adverse effect on the interests of the defendant.
So the judge recognized she would be left with zero time to prepare.
That's why the court was trying to protect her in the first place.
But despite that protection...
So this is important, guys. So what it is saying right here, too, is that what she's filing for now, which is for a new motion because of her attorney, the judge tried to prevent that by refusing to let her attorneys go. But if she's not, number one, giving discovery, which it shows, even after they left, Robin had to try to chase her to answer these forms and answer basic questions. She just was not complying. So I'm sure the lawyers were faced with the same thing. Nobody wants to be connected to a losing case. This is my opinion. You're not giving us the evidence. You're trying to probably hide. How can we give discovery when you're not giving us anything to discover? She probably was embarrassed. She knew that this was bad.
Now we have some theories on this side too.
Go ahead, baby. Hit me up. Let me know.
That your favorite gerontologist, he believes that Brenay had been receiving help the entire time, and they're wondering if it can be proven that she was receiving legal help during her whole trial and possibly throw out the appeals motion because of it. You know what I mean?
That could be definitely because she had some people sitting next to her. To my understanding, I think they was giving her basic information. I'm sure if Robin does see that, then it, to your point, will help.
Yeah,
to add to that, the biggest thing though is that she did not give her attorneys what was necessary for them to help her. And she was not paying. Matter of fact, I'm going to ask it again, but it looks like she was not paying her attorneys. So not only are you not giving me discovery, that's what it appears to be. We are not lawyers. We just smart people know how to compile information. Not only are you not giving me the evidence, but you're also not paying. So how can I give discovery? So now you're trying to say that the lawyer didn't do what he needed to when you yourself did not provide him the information to do that.
Correct. Like you said, they weren't in your bedroom or bathroom.
This happened in May.
Or car.
Where was your attorney? You went to Vegas? You're shopping at TJ Maxx. Like all this stuff is going to be, Robin is not dumb. And people are sending her stuff like every day.
Yes.
All of this stuff is being seen. This is why I personally believe that her best chance of it is probably getting a reduction. Because as we discussed, I don't know if y'all just came in, they didn't specify what the money was for. They did in the 1.75, and they needed to do that. So maybe reducing that. But outside of that, nobody's giving her a new trial. You had plenty of time from May up until now to get an attorney and get some of these questions.
Okay, go ahead.
Make sure I don't got no question. Let's see, babies. Knowing when to suffer, her mom was telling, and in court, you only filed because I took your spot. Oh, girl. Hey, say what? You know what I'm saying? You only filed because I took your spot. Very arrogant. Those transcripts that you're asking for now, we're going to hear that. Those transcripts that you're asking for, we're going to hear that. She did herself no favors. So this is why I'm thinking that her best chance may be getting a possible reduction. But even now, you don't have an attorney. You have a limited attorney who's doing a limited appearance. Look, are you going to put the money out for an attorney or not? It's like nobody wants to be sitting down and then risk seeing you do this foolishness.
That's what your favorite said. That it's limited because she doesn't necessarily want this on her record. You know what I mean? So if now I'm gonna help with this, but that's it. You know what I'm saying?
Really? So nobody wants to sit through that, even for fun. Nobody wants to sit through that. Like you already got one you're dealing with that's coming up in January. Let's go. She just refuses to pay the money for real. Yeah, she's being arrogant, and she's making this more and more eyes on this now than ever. That's her fault.
That's her fault.
And it's accumulating interest. Yes. Thank you, A. I appreciate you, baby. Thank you. I love donuts.
Protective order. The attorney.
Donut. Oh, dope.
You made an oral motion in May, and the court granted it with the defendant's consent.
And that's the moment where all that legal protection seems to have just evaporated, pulling her to the brink.
That is the hinge moment we were talking about in this Rule 59 challenge.
And the defense now argues that allowing that withdrawal, even with consent from a person they describe as having limited legal sophistication, was fatal.
That is the third
Susie, don't you say that.
Trial motion.
The new defense team is using that lack of discovery, which we just discussed, as the main proof of prejudice.
Because the attorney who left conducted, and this is the quote, no meaningful discovery during his entire time on the case.
No meaningful discovery. What does that actually mean for a trial like this?
It means the defendant walked into that courtroom completely blind.
The records show her lawyer issued no interrogatories, no written questions to the other side.
Oh yeah, let's hear it.
But how can he enter whatever you just said if Brenay does not give the information that's being requested?
I agree, LaTwyla.
Okay, let's unpack this apparent contradiction.
You are connecting two parts of the legal failure.
We talked about her failing to provide her own evidence.
Things like her income documents, influencer brand deals, and communications.
And now we're talking about the lawyer failing to gather evidence from the other side.
The lawyer failed to issue interrogatories, no written questions to the plaintiff.
No requests for documents or depositions of witnesses.
They're two separate but equally disastrous failures.
His failure to conduct discovery is procedural.
It means the defense didn't even attempt to learn the plaintiff's strategy.
Her failure to comply with discovery means the plaintiff had grounds for sanctions against her.
The new defense team is fighting both, but the lawyer's failure to do any work, the no meaningful discovery, is the core of their Rule 59 argument.
Because even if she was slow on her own end, the attorney should have been aggressively pursuing information from the plaintiff.
He was running $1 million defense on basically hope, without any of the tools required.
And the lack of those... Oh yeah, let's hear it.
So the question too is now when we had the actual trial, she had no meaningful evidence either. She only provided maybe 2 or 3 pieces of evidence.
That is a critical observation that absolutely connects these dots.
Okay, let's unpack that lack of evidence at trial.
You are confirming the ultimate result of that failed discovery process.
Yes, the motion confirms she had no meaningful defense evidence to present.
Because the attorney who left did no independent investigation into the allegations.
No subpoenas for records, no depositions, and no internal investigation.
The CART motion specifically states that the plaintiff presented little to no evidence of actual damages.
But the defense side had the same problem.
Exactly. The defense walked in with 0 accumulated evidence to mount a proactive defense.
So when she...
Oh, back to our listener.
I hate to cut you off, but could her previous attorney be called against the appeal process? Could this be used by the judge because of what happened?
Exactly, Hazel.
That is a fascinating question about professional accountability.
You are asking if the former attorney's failure can be used against the verdict.
Okay, let's unpack this. We've established that the former lawyer, Mr. McDavid, conducted no meaningful discovery.
That failure is actually the central argument in the Rule 59 motion.
So yes, the new defense team is absolutely using what happened with the previous... Oh, yeah,
Could the attorney himself be called against the appeal process?
Could the attorney himself be called against the appeal process?
That is a phenomenal follow-up question.
Okay, let's unpack whether Mr. McDavid would be called as a witness.
When we talk about the Rule 59 motion or the appeal, we are talking about reviewing the process of the trial.
We are not relitigating the facts of the affair itself.
So the lawyer himself is highly unlikely to be called to testify against the verdict.
The new defense team doesn't need his testimony.
They are using the procedural fact of his failure to conduct discovery.
And the court's own earlier ruling that withdrawal would be materially adverse to Kennard.
That denial, followed by the later withdrawal, is evidence of a fatal procedural error.
This is the third ground of their motion, the catch-all provision, Rule 59.
It argues for a new trial based on manifest injustice due to the withdrawal and lack of preparation.
Jim, so she's appealing because the attorney didn't do their due diligence. Yes, but also the attorney didn't do their due diligence because something got hung up on Brenay's end. It appears 2 things were happening, and this is just my opinion. Number 1, she didn't provide any evidence. She wasn't answering questions. We know this because even when the attorney was no longer in play, Robin had to chase her down for evidence, to answer her interrogatories, all her paperwork. She just would not respond to basic questions. So she'll put one sentence and things like that, to the point where Robin got really specific. Answer it like this, do each line, answer these questions separately. Like, she had to be very exact with her because she was not asking or answering the questions as she needed to answer them. In addition, it appears that she didn't pay one of her attorneys. So, of course, he wouldn't do his due diligence. You're not, number one, giving me the evidence, and this is just what looks like we seeing.
Yeah.
Two, you're not paying. So what on earth can he do? This is why I'm saying, like, this is just a joke. Because even if you take them out of play, why didn't you get an attorney now? Because you're saying that she got set up, basically, by going in there and being her own lawyer. What happened all those months? You clearly had money. You were out of town. You were showing everything on the internet because you can't help but show everything on the internet. So what happened all of that time? She also wouldn't show up for court, right?
Yeah.
So people having to chase you down, like all of that
stuff.
Yep.
Look what you said. That's insane.
So the judge is looking at the lawyer's actions as proof that the trial was fundamentally unfair.
Yes,
it wasn't about the lawyer being bad, but about the prejudice it caused Ms. Kennard.
Because when she went to trial, pro se representing herself, she had no tools, which you pointed out.
No deposition transcripts to challenge witnesses, nothing at all to counter the plaintiff's narrative.
The motion argues this directly led to the unjust verdict.
She was taking on a professional boxer with one hand tied behind her back.
Lord.
That is the perfect analogy.
And the lack of those tools is why they claim the trial was fundamentally unfair.
This whole procedural history paints a picture of systemic legal failure on the defense side,
which culminated in that $1.75 million verdict.
So the stage is set. The new defense team is arguing that this whole judgment needs to be tossed for 3 specific legal defects.
Let's tackle the money first. Ground 1. Excessive damages influenced by passion or prejudice.
Here's where it gets really interesting.
Right, this is Rule 59.6. And it's the argument that could really collapse the entire verdict.
They claim the jury's $1.75 billion award is fundamentally flawed.
Because the jury didn't follow specific instructions about damages.
We talked about this earlier, the difference between two types of financial recovery.
Exactly. The jury was told to decide if their award was for nominal damages.
That's a trivial sum, maybe $1, just recognizing a legal wrong was committed.
Or for actual damages, which covers real quantifiable harm.
Right, things like mental anguish, economic loss, that sort of thing.
Wait, if the jury awarded $1.75 million, surely they meant actual damages?
You'd think so, but this is the core of the legal argument.
The verdict form they were given only had one blank space for the monetary award on each claim.
Just one line. So the defense argues that because the jury failed to specify what type of damages they were awarding, the court can't legally uphold that massive figure.
So what does this all mean? What's the legal implication of that?
If the court can't determine the basis for the award, they might be forced to default to the lowest possible option.
Which would be nominal damages, as trivial as $1.
If the defense...
Oh, yeah. Go on.
So you say that the court, there was only one line, but isn't this the same for previous alienation suits? If it's one line in the past, it would be one line now.
That is a phenomenal question about legal precedent and procedure.
Okay, let's unpack this. You are asking if this single line issue is typical.
In Hartbaum cases, a single line for the amount is common on the general verdict form.
However, the jury instructions given by the judge were very clear.
They mandated that the jury consider and find 2 separate values relating to damages.
Specifically, nominal damages and actual damages.
Here's the key. The Rule 59 motion cites a specific bankruptcy case in Raymond Martha Medlock Gallagher.
In that case, the jury also failed to distinguish which tort they were awarding money for.
This failure was critical because criminal conversation judgments could be discharged in bankruptcy.
But alienation of affection judgments generally cannot.
So if the jury doesn't specify the type of damage as instructed, it compromises the verdict's legal integrity.
Even though the form only has one line, the instructions require a clear finding.
The defense argues the lack of parsing the damages, even with the one line, creates ambiguity.
They're saying the procedure.
All right, guys, as we see, the chances of it being reduced is probably her biggest thing thrown out.
The biggest Hail Mary.
But that's what they messed up at. If they didn't specify what was for what, then this is going to probably give her the argument she needs to get it reduced. First of all, Brenay don't have, I've been telling y'all, if y'all been with me, Brenay don't have no millions of dollars. We know that.
Yeah, we know that. Of course not.
she don't have no $1 million. She got some little change, but she does not have that amount of money. So we already knew she wasn't gonna get that know-how. And even with the new figure, it's still gonna hit her where it hurts. Okay, so we're not even worried about that. Please like the lives, baby. Please like the live.
Please like the live. Please like the live.
We got some
Thank you so
people
much.
in here. Please like the live. If you are finding this to be helpful,
Value.
like the live. That helps us out a lot.
Yes.
What I did was I put together all of these. I had to download all of these court documents. I put them together.
Put some time into this, man, and this was extremely smart to be able to break this stuff down for us to hear it and understand it.
I prompted it. Thank you, Kim Brenay. I appreciate you, baby.
Yes.
I had to prompt it because I love prompting so much. I had to prompt it so that it could put together in a way that we can understand. So please live, let TikTok know we over here providing value. Let's continue. Did you want to say anything, babe?
Oh no, I'm just going through my questions real quick. She has zero evidence. No, it's comments based on what we've been hearing.
Okay.
Procedural flaw in the form, combined with the instructions, transforms the entire verdict.
And that this ambiguity makes the $1.75 million unjustified.
So a multi-million-dollar verdict could still turn into a symbolic $10 award.
If the defense can argue the jury might have just been awarding a passionate but nominal amount, the whole figure collapses.
It's the difference between a minor legal loss and complete financial ruin.
That procedural error is a huge leverage point for the defense.
And they back this up by arguing there was a severe lack of evidence for such a huge actual damage award anyway.
Exactly. Going back to your observation about the minimal evidence at trial.
You can't just claim mental anguish for millions. You need to show the proof.
And the defense says the plaintiff presented little to no evidence of that quantifiable harm.
For instance, there was no clear testimony on the cost of the plaintiff's therapy.
And crucially, no clear evidence of the husband's salary or how much of it was actually going to support the plaintiff.
They're essentially saying the plaintiff didn't bring the receipts needed to justify that colossal bill.
That's it. And what's more, the defense notes that evidence was presented that the plaintiff's own mother had to provide financial support,
suggesting the husband was already unable to support her financially before the defendant got involved.
Child basically saying Tim ain't worth no damn 1.75.
He ain't worth no damn 1.1 million. 1.5 million.
She feel like she should get million. That's
so him leaving was not going to be, not leave her $1 million short, basically.
which undermines the claim of massive economic loss.
Exactly. Okay, that brings us to ground two.
Insufficiency of the evidence for the $1.5 million alienation of affection claim.
This raises a big question. What was the real state of the marriage before the defendant showed up?
This is a really strategic attack on the core elements of the AA claim.
Remember, to win on alienation of affection, you have to prove a genuine marital relationship existed.
Meaning there was actual love and affection there to be lost.
The defense argues there's a huge problem here because the plaintiff's own complaint admitted something crucial.
That the plaintiff's husband had previously had an affair with another woman before the defendant got involved.
So the defense argues the marriage was already in danger and strained for love and affection.
And that the plaintiffs failed to show the marriage had fully rebounded from that first traumatic event.
This directly challenges whether the defendant was the controlling or effective proximate cause of the marriage's destruction.
If the marriage was,
But couldn't we also say, since if that was the case, that it was a fracture, that Brenay coming in and doing what she did could have made things compounded?
That is a phenomenal insight.
Okay, let's unpack this idea of compounding the fracture.
You are hitting on the precise legal counter-argument that the plaintiff would make.
While the marriage might have been shaky, North Carolina law recognizes that there can be multiple causes of alienation.
Here's the key. The plaintiff doesn't have to prove the defendant was the sole cause.
They only have to prove that the defendant's conduct was the controlling or effective proximate.
Absolutely.
So even if the foundation was shaky, as the defense argues,
Brenay Kennard's actions could have been the final decisive blow.
the documents indicate the
Make
plaintiff's
him walk out.
detailed many actions designed to seduce the husband.
Things like wearing very short skirts and flirting to interfere with the marriage.
These acts
Which she
happening
did.
after the prior affair could be viewed as the effective cause of destruction.
The jury must have believed that the marriage, despite its cracks, still had a genuine marital relationship,
Meaning some degree of love and affection remained.
and that the defendant's actions were the one thing that finally destroyed it.
If the jury found that the existing relationship, however fractured, was alienated by her actions.
Then the $1.5 million AA verdict stands.
So the defense is trying to redefine the marriage as already dead.
But the plaintiff successfully convinced the jury that the relationship was just fractured, not destroyed.
And that the defendant delivered the fatal blow.
This directly challenges whether the defendant was the controlling or effective proximate cause of the marriage's destruction.
If the marriage was already broken, the defense claims the $1.5 million verdict cannot stand.
This is truly a case of high-stakes legal maneuvering.
The outcome of this Rule 59 motion will determine the entire future of this verdict.
And whether Ms. Kennard faces that $1.75 million judgment or gets a fresh start.
Thank you, Tina. Appreciate it.
Follow this dramatic legal saga.
And thanks for all your fantastic questions and insights, too.
All right, that one was
I got a good question for you. That was, first of all, that was phenomenal. I'm just going to give you your roses. I'm going to give them to you later, but I'm going to give you your roses because not only did you put all that together and do all the prompting and ask the questions and that needed to give us that information, you made it interactive so we can go in there and ask questions based on, or you can go in there and ask questions based on what we were hearing or what they were explaining. That was just genius. So thank you for that. I appreciate it. I got a question for you.
I got all the documents. We can really start breaking down all any number of.
I got a good question for you. So your favorite said, what course do the hosts, I believe they're talking about us, believe Robin will take to defend this?
What course?
Yes. So what would Robin do basically to defend this?
One of the things I think she's going to take is what we just talked about. So they're basically saying that because the attorneys didn't do what they needed to do on their end, providing discovery, evidence, and even calendaring the event. I want to go back really quick because I want to go into calendaring the event. The lawyers didn't do something in terms of putting something on the calendar, and that one thing did mess stuff up. So I believe outside of that, the defense is you didn't give your attorneys what was necessary to do what was necessary for you.
Okay.
In addition to that, you signed off on the withdrawal. In addition to that, it appears, and I said it appears, that she did not pay. That was in the court documents, that she didn't have the money necessary to pay. So whether she withdrew because it was becoming expensive, because one of the reasons why it was becoming expensive was because Brenay wasn't answering questions and did what needed to be done. So they had to keep filing.
Delaying it.
And so now my the people that you protect, my client is not going to have to foot that. Why should she have to foot the cost
for you to delay,
chase you because you're delaying and all of that kind of stuff? So that stuff was starting to stack up. This is why she had the $2,000 that she owed.
Yeah. Before jury even got selected or anything.
So I believe one of the things Robin is going to say is that was you not working out with your attorney. That was on you. Not only that, after that, let's say that didn't work for whatever reason, you had months to bring somebody else in. And who knows what the courts would have done had an attorney came in at the last minute. They may have given you another extension.
Correct.
Because the attorney would have needed more time to get discovery, but you didn't do that. You thought it was a game.
Yep.
So that's what I think she will do.
I agree with Swallow. Yep. I think that she's going to do what she was prepared to do in the first place had she had an attorney. I believe they have the information they need from the psychiatrist to prove the mental strain it was putting on Akira. I know they have the bills. They have everything that is needed that Brenay, because she was lacking, did not ask for. So I think that she's just going to be able to use everything that they already have. And I think somebody, I don't know if it was LaTwyla or somebody else made a comment that she may be putting herself in that trick bag by exposing something that didn't come out before if they have to go back into this. So I think Robin is prepared, had been prepared, and just did not, things that didn't come up or come out is because Brenay did not ask for them.
To me, it is not, to me, the biggest thing that she has going for her is that the jury didn't specify on that one line, how did that divide that money up? That's the biggest thing that she has for her. Other than that, all of the evidence
is still there.
They're going to show all of that. They're going to go, because we're also, in addition to you requesting an appeal, you're also asking for a new trial. So they're going to have to look at that and see if it's worth it. All of that evidence is there. All of the stuff that you did in the bedroom and with the video cameras and all of that that's not going anywhere.
Still there. And most of it was yours and Timothy's phone.
She filmed the whole thing herself. The whole project. Y'all have to understand this. And this is in my opinion. The entire movie is Brenay. She wrote it, she directed it, and she produced it.
And she's
still doing it right now because she can't not help it.
She can't help it, yeah.
Akira, if y'all don't know, if you just coming on the tail end of this, Akira did not want this to go to the public. She asked, can you please keep this away from the internet?
Keep it private, yep.
And Brenay's response was in and about everything is content. Well, then let it be that. She even said that in court. So she produced this whole movie. She produced the reason why we're talking. She produced the reason why The View had it, the TMZ. This is her in production. So then now you can't say, because one of the things she said too in her recent thing was something about emotions. I want to hear what that said really quickly.
She was emotionally something. So she had to file something for her emotions, child. Her emotions.
Yeah, I want to hear what it said real quick.
Please live, babies, if y'all coming in. If you found value, please like the live.
I was about to ask a question.
I'm sorry, go ahead.
1 second, babe. I'm sorry, I have a question. In the filing, Brenay said something about her emotions. Can you elaborate on that?
That is a great question.
And you picked up on something vital.
You're asking about the defendant, Brenay Kennard.
Yes. Her emotional state and claims are very much part of the defense strategy.
Specifically, she made some admissions.
In her answer, she admitted to some of the specific allegations.
These were the allegations about her expressing inappropriate feelings.
Things like her desire to have children with the husband or wanting his last name.
And crucially, expressing how he made her female genitals throb.
Right, these very detailed, raw, emotional statements.
Now, here's where the defense attempts to mitigate that.
Kennard's legal team claims she was under the influence of alcohol.
She argued that she apologized for these statements.
And that the plaintiff, Akira, actually forgave her for them.
And this is all part of the back and forth in the legal filings.
So basically, she's emotionally all over the place, which is why it didn't go the way it needed to go.
No.
Oh, this is Susie. I had to go in, and it's not an app. I had to compile the documents, and I prompted it. So it's an app, but I had to create it. So I had to go in, grab the documents, prompt it to do what it needed to do, ask specific questions, and then it gave me this. So it's almost like advanced. ChatGPT could do it, but you would have to go in, download all of the arguments, and it wouldn't be necessarily like this, but it'd be almost.
Because you curated it to be able to do this.
Yes.
So anything that would do this, you would have to curate as well. ChatGPT, whatever.
You have to grab all the documents and then do that, and then have to go back and forth.
Yeah.
But they are married now. Sorry. Let me see. Hey, how y'all doing? You did a phenomenal job. Thank you, Sylvia.
She's trying to gain momentum since it has gone national.
Exactly. Anything specific in these filings that she did? Anybody have a specific question they want to know about what she filed yesterday? I'm able to pull that up. Yeah, in my opinion, she took this as a joke.
Of course.
And it was not a joke. So when she said a TikTok video, I'm going to have those babies sober, wouldn't that cancel it out? Yes, everything that she did is knocking against one another.
Yep.
Everything she did. The only footing that she has is that the jury made a mistake in that they didn't specify how that money should be divided up. That's why her having a chance of it being reduced is there, but they may feel like even with that, forget it. Who knows? Who knows? But that, other than that, getting a new trial and all of that, because the last thing folks want is to get a new trial, and now you're prolonging it again and again.
She has wasted these people's time. And folks are sick of it.
So she doesn't have to pay Akira anything until it's on hold.
Right now, yeah.
The money is on hold, but the interest is still accruing.
Since the appeal was filed, it's been on hold.
Interest is still accruing. So if she loses this, it's still going to be interest accruing during all of this.
Thank you, Latwala.
But they can't come after her or grab her money from Snapchat or what have you. They can't do any of that.
Yeah, tried to blame it on alcohol and say she doesn't really drink, but then they had videos of her buying a bunch of wine or something like that. So it's like, what is it? What it all comes back to is Brenay fabricates.
Okay, I want to see something real quick. So we can know too, the court dates that are coming up. November 25th, Tim has a hearing at 8:45 a.m. for that pew thing that he did. And that's him walking into the courthouse with a pew. So he has that coming up at 8:48 a.m.
Next week.
On December 9th, will they make her take it out in escrow? Will they make her out in escrow? Tell me what you mean, baby. Will they make her put it in escrow until she don't have 1.75 million? So probably not. Yeah. That would be, me and Sharice were joking about that before. Does she even own that home? No. It appears that she's renting the home.
Yes. That's what it looks like.
Yep, that's what it appears. They checked on that. So she doesn't own that house. Like she's renting it.
And because she does not have this amount of money that she actively has liquid right now, when they make her pay, it'll be like percentages. It wouldn't be, they wouldn't go after and take all of it because folks they do know, they give you an amount to live on. I think it's 20% or something that will be paid to her out of whatever she earns over time.
The defense is using.
Oh, go for it.
Will they take all of the judgment or will they take a percentage of it? Did you know that? If she, it cut me off.
That is a phenomenal question about the actual mechanics of the money.
And it gets to the heart of why this post-trial fight is happening.
You're asking, if they lose, does the defendant pay the full $1.75 million?
No, she gonna pay that.
Yes. The court ordered the full sum, $1,750,000 plus interest and costs.
So on paper, the plaintiff, Akira Montague, is entitled to recover that entire sum.
That order was recorded on November 12, 2025. It's an official judgment.
However, that huge figure is exactly what the defense is trying to reduce now.
If the defendant, Brenay Kennard, successful argues for a new trial under Rule 59, the money award could be thrown out completely.
Or if the judge agrees that the damages were excessive, they could amend the judgment.
Meaning the judge could take that $1.75 million and lower it substantially.
So while the judgment is for the full amount, the defense is hoping to change that number to 0 or a much smaller percentage.
It's all about keeping that money from having to be paid out.
Okay, let's unpack that.
Oh, yeah.
So what I'm saying is, will they take a percentage of her money versus taking the whole? Oh, we know she don't have the whole thing.
Very important clarification.
You are asking about the mechanism for collection.
Yes.
Yeah.
We're talking about taking a percentage versus seizing the whole amount.
The order itself, the $1.75 million, is a fixed amount.
It's not a percentage of the defendant's income.
It's a sum they are legally required to pay the plaintiff.
Now, how the plaintiff gets that money is a different battle called execution of judgment.
Okay.
If the defendant has $1.75 million in the bank, they could pay it all at once.
But if they don't, which is often the case with such large sums,
The plaintiff would pursue collections.
that could mean liens on property or garnishing wages.
Since the defendant is a social media influencer with multiple income sources.
Including brand deals and commissions, the plaintiff's attorney has been aggressively seeking disclosure of that income.
They're trying to find out exactly how much she makes and where.
This helps them calculate how much money she can actually pay and how fast.
So to answer your question, the judgment is the full amount.
The payment might come in percentages over time through garnishment.
But the goal of the...
So what we know Brenay ain't got no, Brenay probably ain't, in my opinion, Brenay probably ain't got a couple thousands in that joint. Like,
no, she got Tim's, if she would have Tim's back child support in there right now, to be honest.
So we know she don't have
through it.
$1.75 million.
Yeah.
So this is why I'm thinking that they will probably definitely reduce it. How are they going to get it? They're going to probably definitely go for Snap, TikTok, any other places that we see her roaming around right now, and any brand deals she may have. And this is the thing too.
Why?
She has so many people who are looking at her right now that somebody will see her pop up anywhere and going to give it to Robin. That's what they've been doing. Waiting.
They look like they scared to go outside because people is videoing them, taking pictures of them. Yes. It's bad out there in them streets, in them North Carolina streets for them.
Okay, some people keep asking me about that, what I did. So what I did was I had to download all of the documentation, all of the actual documents for court. And then I had to prompt this thing to be able to give me what I need. So this is a school in prompting. If it's prompting is something that you guys want to learn, I will probably be talking about that, not this month, but next month to help you prompt. But prompting is, people are getting 6-7 figure jobs right now behind prompting. Prompting is, you can get anything you want. So that's what I did. I downloaded the documents and then prompted it to give me what I needed to be able to talk to you guys tonight.
Yep, Miss Higgins, she still has a cyber stalking to face. Yep, that's next month.
Yeah. So let me run down the case, the dates that are coming up again. November 25th, Tim has his hearing for the pew at 8:45 a.m. because he walked into the courthouse with a pew. He said it was accidental, but it was also right after they called him Timmy with the hips. I'm just saying, because I was looking at that live when it was going down.
Facts.
At 12/9, Brenay has her cyber stalking case with Akira. So we're going to probably be hearing some stuff about that. On January 22nd is Devin and Brenay case. This is going to be for him saying, basically, I was with you when you was doing them videos, where my money? Okay. Now, Devin also has a case that's coming up with Tim for the alienation of affection, but that's placed on hold right now.
Temporarily, yeah.
Moving on, but it's not over. Matter of fact, I think there was a motion or something that went down a couple of weeks ago, or maybe it was last week. So Robin, who is representing him, is active on that, but right now it's just on hold.
Temporarily.
I mean, look.
Yeah, I thought it was intimidation too, but then we thought that he didn't want to. It was bad in court, and he didn't want to go back in there having to listen to any more of that, and or didn't want to have to get up on the stand and try to basically get himself in trouble to be in lockdown. When in actuality, it doesn't matter. If you in lockdown, you still in the courthouse. They'll bring you up there to testify, and then you got to go back downstairs and do your time. So it was senseless anyway.
Period. Okay, babies, but we hope this has been helpful for y'all. Please like our live.
Please follow us so that you are aware when we go live. We go live every day at 7 p.m.
Yes.
And we are trying.
What stops her from dropping? I mean to cut you off, baby. What stops her from dropping her attorney if there is a retrial? Exactly, Renee. Nothing. This is what we're talking about. Like, she could do the same thing all over again. She's probably litigious. Yeah. One of them people that likes to run through the court system over and over again, holding up people. I actually had dealt with somebody like that before for my Triple Crown publication for my very first books. This person knew the court system and knew how to just hold stuff up in limbo. So she may be one of them litigious type of people that just be throwing stuff off. So that's what we're saying. Nobody wants to be dealing with this again. The very least that she may get is a reduction in this amount. Okay.
LaTwyla said that I believe that she's speaking of the Devin and versus Tim. Case said it was placed on inactive status because they were unable to serve Tim initially.
And I think they got him though.
Okay.
I think something went down if they didn't get him, I believe something just went down, something that happened recently.
Okay.
However, thank you, Sarita. It's 7 p.m. Eastern
Standard, yeah.
We go live 7 p.m. Eastern. I believe something may have happened and they got him. I believe so.
She said, they did recently serve him.
If they didn't know, he has court coming up.
Yeah, so they could serve him there because he better show up for that.
It ain't gonna be no problem.
Yeah.
They served him in court. Good. Yeah, they served him last week. Yes, I thought so. Good. Yeah, so he already got his paperwork in, which was the holdup. Folks is not playing
at all.
I know she think it's a joke, and she doing these ugly faces on Snap and with lip gloss and all these fake comments. You're so beautiful. It's just gross. I know she think it's a game. It's not a game. People are
not playing with you. And they're tired of, in my opinion, the courts don't like foolishness to tie up the dockets. It's too much other stuff going on.
Think about Akira though.
And you playing.
This is so freaking draining.
Thank you. I said that when I was driving in here. Trying to get in here.
Hot Books by Amber.
Oh, Hot Books by Amber.
Not my real. I didn't give birth to her, but one of my that's one of my babies who I was in my Elite Writers Academy when I was teaching people how to write urban books, books in general. Period. Go ahead, baby.
I really just said a quick prayer for Akira because
love you.
I know what the outcome going to be because no weapons formed shall prosper. I know exactly the maliciousness by which they are handling this situation. Brenay, Tim, Corinne, Lakeisha, all it could be harsh, and this is very draining to your point on her, and I'm sure the kids. But in the end, I know she will win. She will be justified. If we play devil's advocate and all of this stuff gets thrown out and Brenay don't have to pay, at the very least, she has removed these demons from her life.
That's what I said.
These people from around her kids, just like you said last night, and because they are dangerous, calculating, malicious people that she needs to be, her and Devin, because we keep Devin, not we, because we don't forget him, but a lot of people keep forgetting he's also a victim in this situation. He was married to him doing all of this, but they just overlooked that. So I believe that they win, those two win in just getting these people away from them. But I know that ain't how it go because bullies got to pay. And they will. In the
And
end.
to add to that, like even with the narrative that The View, TMZ, and a lot, thank you.
Love it. Come on, cowgirl.
Even the narrative that they try to play when they talking about this case, they always talk about Akira and Brenay. They never talk about the third party. That's what makes this case so popular. It wasn't just that a woman stole a husband. This person was married. It's like they don't even mention that. Like it's not even mentioned. But to your point, I want to harp on that again because a lot of people are very hurt by this, and I get it. I just want, like Sharice saying, for us to remember that we needed eyes on these people. Because in my opinion, these people are very calculating, and they were, in my opinion, very dangerous. Akira herself pretty much explained that she suffered the PTSD, couldn't walk in certain places, couldn't do certain things. Thank you, Talk, baby. I appreciate you. She herself said she couldn't go places. This was draining on her spirit. So now all eyes are on you. Even the little things that I feel like they were doing, which was going to the range, all that to bully people, to try to intimidate people. Thank you, June. Folks was not playing that. Folks is not playing. So we needed eyes on them. Akira is going to be better after it. She just got to get over this hump.
That's it.
But even if she doesn't get anything, which we know that's not the case.
No, she definitely gonna get hers, and she'll get what she has coming to her because she deserves it.
People are looking at this now. Y'all can't bully her any longer. Y'all can't come
shadows in the dark.
Kids. Y'all can't do any of this no more. Right. And I'm hoping that she gets full custody.
That's what I said. My hope for her is to get full custody of her children and leave Brenay and Tim and the rest of them to it. That's what I want.
Yeah. So this happened for a reason, babies. I know this is heavy. This happened
and she's growing from it, and she's getting stronger from it. And that's why I keep prayer over her, because going through this, even to make you stronger, it takes you basically being broken down to be built back up. And that's not fun. So I am encouraging anybody that does pray to pray over her and her babies for their strength.
June says she and Devin have a lot of people online in real life standing by. You know what I'm saying? In real life, IRL. Brenay had a couple, 2-3 people, and people were upset. They were like, man, the people around. Villains got a team.
Yeah.
Villains got a team. They almost got to do that. But look at the people. She had her family, and she had. It is going to be bigger than that. Like now, it's so many people. It's even more people who are praying for her. Even The View, they was like, yeah, absolutely. You sure should sue? Like,
you made it to The View. Come on now. Yeah.
So y'all just be easy with that. And if Brenay is rattling the spirit, because she tends to for a lot of people, just like Miss Netta, honey. Miss Netta gets on everybody's nerves. And there be people that be really mad. Just take a break from her.
Yeah.
Just take a break from her.
Yeah.
Come on over here and let's talk about it on this end. And that way you ain't gotta worry. Why would anyone say on the news camera that you're not gonna pay? This is why I say this is why I wasn't buying one of the avenues Sharice was saying that she is probably calculating. She's not, you don't do that. She thinks in the moment.
Yeah, that's so true.
In the moment. And that's not how life works. There's plenty of things that I want to do or would have loved to do that I can't do. I have to think about the future. Brenay does not do that.
Sharp, welcome.
Who did? Yes, Susie. It was talked about on The View.
The View.
They weren't there, but it was talked about on The View. The View were talking about it today. It's on YouTube. Yep. They would talk, and if you do TikTok, everybody clipped it and reposted it. Yes. On The View, they talked about it. I read that statement as a dangerous threat. Which one?
Thank you, Me Sharp. I appreciate it.
Which one, Susie?
Hey.
Yeah, she's not, nobody is playing with her, and everybody is watching. Everybody is looking. All Akira has to do is stay prayed up. And I encourage everybody on here who's looking at this to get yourself a spiritual practice. Oh yeah, she'll never see it. She'll never see it. I don't know, but she'll never see it.
She'll probably never see it.
She'll probably never see it. Yeah, this is why everything that she says is going to be used against her. So the thing is, we'll take a little bit of change off because you don't have 1.75 million anyway. We'll take a little bit of something to change off. But what about the poetic justice? If Akira get that story, her story comes out, a major network, and if I could write it, that'd be even better.
That'd be even better, yeah.
Come and get her and then tell her story. So then she get 1.75 million and then some.
On top of getting paid for her story. Now that is and that's not far-fetched.
No, it's not far-fetched.
Come on now. That's easy.
Right attorney.
That's easy. Yep.
Yeah. So
D Sharp said the mindset of Brenay is dangerous.
And very childish. That's why we are where we are. All right, babies. I hope you enjoyed the program tonight. We will be back tomorrow at 7 o'clock p.m.
Please follow us. Don't forget to follow us. Don't forget to follow us. Yes.
All right, honeys. Talk to you guys tomorrow. Good night, baby.
You guys. Thank you. Appreciate all the likes.
Good night, Kim Renee. Thank you for supporting me, Kim Renee. I like your toys by your name. Bye, June Jim. Bye, Toy Box. Bye, babies. Good night, Susie Q, baby. Good night, Waffle. Susie Q said good night. He gonna blow out. Good night, baby. Damn, Sharice. Just hung up. Good night, good night. Good night, Tricia. Good night, babies.